Bon matin à tous.
Good morning to you all. Welcome on this December 16th, which is perhaps the last day of Parliament sitting before the holidays. This is the 39th meeting of the Standing Committee on Official Languages.
Study of the offer of bilingual services at the Immigration and Refugee Board of Canada. Nous avons ce matin le plaisir de recevoir.
We have the pleasure to receive this morning officials from the Immigration and Refugee Board of Canada. Without further ado, we have with us Diane Lascelles, Serge Gascon, Sylvia Cox-Duquette, and Mr. Simon Coakley, who is the Executive Director. I'd invite him to begin with his opening remarks. Thank you, Mr. Chair. Good morning to you all. My name is Simon Coakley. I'm the Executive Director of the Immigration and Refugee Board of Canada. I am the board's Chief Operating Officer, and I am responsible for the performance of the board's adjudicative support, registry, and corporate support services. I report directly to the chairperson, Mr. Brian Goodman. I'm joined today by Ms. Diane Lascelles, our Director General of Human Resources and Professional Development, Ms. Sylvia Cox-Duquette, our Senior General Counsel, and Serge Gascon, our Director General of Corporate Planning and Services and our Official Languages Champion. We are pleased to have this opportunity to meet with the committee and to provide you with information about how the IRB meets its linguistic obligations under the Charter of Rights and Freedoms and the Official Languages Act. Like all federal institutions, the IRB is subject to Parts 4, 5, 6, and 7 of the Official Languages Act, and I will discuss these parts in a few minutes. However, as an administrative tribunal, we are also subject to Part 3 of the Act, dealing with the administration of justice. In addition, the Charter principles of access to justice also apply to our everyday work in terms of individual rights to use English or French in our proceedings, but also in terms of our obligation to ensure that the individuals and witnesses who do not speak either English or French are able to understand the proceedings in which they're participating. In the next few minutes, I would like to outline how we meet these obligations. The Immigration and Refugee Board is Canada's largest administrative tribunal. The board is currently composed of 3 divisions. The Refugee Protection Division, the RPD, determines refugee claims made in Canada. The Immigration Appeal Division, the IAD, which decides appeals of removal orders, sponsorship refusals, and residency obligation appeals, as well as the Immigration Division, the ID, conducts reviews of immigration detentions and conducts hearings to determine if persons may lawfully enter or remain in Canada. When the Balanced Refugee Reform Act comes into force, a new Refugee Appeal Division will be created to hear appeals from the Refugee Protection Division. Each of our 3 divisions conducts hearings across the country, primarily in our regional offices located in Toronto, Montreal, and Vancouver. We also conduct some hearings in our facilities in Ottawa and Calgary, as well as at other locations across the country, including a number of provincial correctional institutions. According to our Departmental Performance Report 2009-2010, in the last fiscal year, our divisions finalized more than 55,000 cases broken down as follows. At the RPD, 28,500 refugee claims, at the IAD, 7,200 appeals, and at the Immigration Division, 3,150 admissibility hearings and 16,500 detention reviews. All of the people appearing before us as subjects of proceedings are asked to indicate to us at the earliest possible time whether they wish their proceeding to be conducted in English or French. In addition, if the subject does not speak either English or French, we ask them to indicate their need for interpretation into English or French. Once the subject has indicated their choice of the language of proceedings, all material submitted by CBSA, acting on behalf of the Minister of Public Safety or the Minister of Citizenship and Immigration, must be filed in the language of the proceedings. If the original documentation is in another language, it must be translated into the language of proceedings in accordance with the applicable divisional rule. When the matter is ready, it is scheduled for a hearing before a board member who is able to understand the matter in the language chosen by the subject. In practice, the majority of French proceedings are assigned to a member whose first language is French, just as the majority of English proceedings are assigned to a member whose first language is English. Prior to the beginning of a hearing, or even during the hearing itself, the subject may choose to change the language of the proceeding. If the minister's representative has any objections to changing the language once the hearing has started, the presiding member will provide the minister's representative with an opportunity to make submissions prior to granting the request to change the language of proceedings. In the event that the minister's representative is not able to proceed immediately in the new language, the matter will be adjourned to allow the minister time to prepare. Any additional documentation will have to be filed in the new language of proceedings. However, the minister will not be required to translate documents already filed in the original language of proceedings. This approach was recently endorsed by the Federal Court.
Proceedings before the board will be represented by counsel whose first language is different from the one selected by his or her client. In those circumstances, the board will ensure that interpretation is provided so that the subject of the proceedings is fully able to understand and participate in the proceedings. The language of the proceedings, though, in other words, the language in which the board member will render his or her decision, is the language chosen by the subject themselves. All of our divisions are able to conduct business across the country in both English and French. However, the demand for French language hearings is concentrated in our eastern region, while the demand for English language hearings is somewhat more evenly spread across the country. And as of December 14th, 2 days ago, the linguistic breakdown of our decision makers is the following. So in the eastern region, we have 54 members, 44 are bilingual, 7 are unilingual French, and 3 are unilingual English. In the central region, we have 111 members, 9 are bilingual, and 102 are unilingual English. In the western region, we have 38 members, 6 are bilingual, and 32 are unilingual English. And a copy of this information was provided to the clerk prior to this morning's session. As I've also already mentioned, once a case is ready to proceed, it is assigned to a member who is able to understand the language of the proceeding. In the event that no member from that region is available to hear the matter in the language selected, a member from another region can hear the case either by video conference or in person. Mr. Chair and members, these obligations are enshrined in both the Charter of Rights and Freedoms and the Official Languages Act, and they're reinforced in our own rules. And as we are a quasi-judicial administrative tribunal, they also go to the very heart of the IRB's raison d'etre and our strategic objective, which is to resolve immigration and refugee matters efficiently, fairly, and in accordance with the law. And this is an obligation we take very seriously. But in addition to this very specific obligation, as I mentioned earlier, we're also subject to Parts 4 through 7 of the Official Languages Act, just like other federal institutions. In terms of service to the public, in addition to our Ottawa headquarters, our offices in Montreal, Toronto and Vancouver are able to provide service in both languages to the public, and our Ottawa and headquarters and Montreal offices are designated as being bilingual for the purposes of language of work. While we're proud of our successes and progress to date, we also recognise that we live in an ever-changing environment where the level of demand for our service in a specific language can vary over time, just as our capacity to deliver the required level of service. Consequently, we're very proud to have a very engaged group of employees on our Official Languages Advisory Committee, which is chaired by our champion, Serge Gascon. This committee has adopted a 2-year action plan which highlights the need for us to continue to focus on specific issues under Parts 3, 4, 5 and 7 of the Official Languages Act. And a copy of the plan was provided to the clerk ahead of this morning's meeting as well. The action plan was adopted before C11 was introduced in Parliament, and as we implement the Balanced Refugee Reform Act, the issue of structuring and staffing the new Public Servant-based Refugee Protection Division and the new Refugee Appeal Division in such a way that we continue to discharge our linguistic obligations to the people appearing before those divisions will be a significant priority. And in that regard, I can indicate that when the new RPD positions are staffed sometime in the new year, we will be identifying the number of positions in each of our regions that will need to be staffed on a bilingual imperative basis, and these bilingual positions will be rated at the CCC level. And now, ladies and gentlemen, my colleagues and I will be very pleased to answer your questions.
Oops. Thank you, Mr. Coakley. So we'll start the first round. On va commencer avec Monsieur Bélanger.
Beginning with Mr. Bélanger. Thank you, Mr. Chair. Thank you, ladies and gentlemen, for being here this morning. I believe this is the first time that the Official Languages Committee hears from officials at the IRB. And so we'll start with the more general questions. I would like to know, Mr. Coakley, how within the strategic plan at the IRB are your responsibilities integrated under the Official Languages Act? The current strategic plan does not mention official languages per se, except one of our priorities, and I don't have this before me, is to continue to deal with issues effectively, equitably, and in accordance with the law and our strategic plan. And as I indicated, language is an essential part of equity. And anyone appearing before us, whether as a person subject to the proceedings or a witness in a case, is entitled, according to the Official Languages Act and the Charter of Rights and Freedoms and Principles of Natural Justice, to appear in the language of their choice. And moreover, and this is something I did not indicate, many people who appear speak neither French nor English, and so currently we have an interpretation service which interprets 260 languages and dialects towards French or English, so that people who appear before us are able to understand the proceedings and feel comfortable. Does the Financial Administration Act, is that act included in your strategic plan? Yes, we're subject to the Financial Administration Act. So all requirements from Treasury Board with regard to official languages as part of the federal institution applies to us. What I find interesting is that the Official Languages Act is not included in your strategic plan. I find that's a gap. It's plan of our human resources plan. It's our human resources plan, HR plan. But and is that not part of the strategic plan? Well, it arises from it. Well, you see, what you're telling me is official languages are not a priority. As an executive, you have objectives that are given to you that are determined annually, no? Are official languages part of those personal objectives of yours? No, currently not. Do you not feel they should be? Well, I feel if there was a problem in official languages, yes, it should. When was the last time the IRB was assessed by the Official Languages Commissioner? To my knowledge, the last time the Official Languages Commissioner dealt with us was on specific cases. So perhaps we should suggest to the Commissioner that it was time to do a review. Because the only exchange that I had with the IRB was in a case dealing with official languages and Ms. Meunde, and the IRB was told that her rights were not respected. And procedures have been changed since that case. We clarified, for instance, in the personal information form, the right to that individuals have of choosing the language of their choice. And individuals have the right to choose their language, but the subjects also can change the language at any time during the proceedings. I did not know that you conducted a number of hearings within provincial correctional institutions. How do those unfold? How do those work? So do you simply use their facilities? No, these are people who are detained by the CBSA. For instance, let me give you an example. Currently, in the media, there are 492 people who arrived on a boat off the west coast, and they're currently detained in a BC facility. And in that case, given the number of people, together with the cooperation from a provincial institution, we established hearing facilities at the provincial facility to conduct reviews. So you conduct the reviews and not third parties. Yes, we're responsible for that. 48 hours after the detention, 7 days later, and every 30 days following that. Okay, very well. Do you know if complaints were filed within the past 12 months? With the Official Languages Commissioner? Yes. 2 complaints were filed. One was settled, and we provided information on the other one to the Commissioner. And before that, I can say that in between 2008 and 2010, we received a total of 9 complaints. Those 9 complaints, if you compare them with the public service overall, for 2010, there were approximately 600 to 700 complaints a year in the public service, and so we receive approximately 3 complaints a year out of 600. That's less than 1%. I had a number issue, but perhaps I won't have time to address it. You gave some statistics as to the number of commissioners who are bilingual and such. Appointments of commissioners are up to the Privy Council. Well, not exactly. The Refugee Protection Division and the Immigration Appeal Division, yes, those are Governing Council's appointment, and the others are public servants. And so the numbers that I gave you were the 3 in total. What guarantees do you have that when their appointments are needed to fill positions, that the linguistic requirements are taken into account? Well, the chairperson communicates with the minister, and if there are vacancies in a region, he will indicate whether there's a need in terms of language as well as a gender balance. So the minister is told what our needs are, and then it's up to the Governing Council to decide who they'll appoint. Thank you, Mr. Belanger. Thank you. We'll move on with Mr. Saint-Cyr. Welcome to the committee, Mr. Saint-Cyr. Thank you very much. That said, I did have the opportunity at the Citizenship and Immigration Committee to meet with IRB officials on a number of occasions. I'm a bit surprised to hear you say that things are running smoothly, there are no problems with regard to the use of official languages. I will deal particularly with the use of French in Montreal. As you know, in the media there were a number of articles criticizing the situation. There were a number of cases and judicial recourse. Lawyers have had to go to federal court. And you're right to say that the federal court did not lean on the side of French in Montreal, but I don't think there's any pride to have won those cases on the use of French in Montreal. The fact is that over and beyond your speech was as theory, in practice, that's not what we see on the ground. When you say, for instance, that people from the outset can freely identify the language they want to use in their proceedings. Well, in Montreal, I've had the opportunity to speak with people who went through the process, and they said that they were never asked what language they wanted to use. For instance, if someone doesn't speak French, almost systematically the English box will be checked without even asking the person's opinion. And then you say that they can ask to change the language in the course of the proceeding, and there's a well-known case when you talk about the federal court where the claimant changed the language of proceedings even before the investigation began, and they didn't want to translate the documents. This is not during the application, this was during the production of documents. And in Montreal, most of the documents are translated into English first and foremost. So there's no way for someone to have the documents translated in French at their proceedings if they were created in English from the outset. I'll ask my counsel to answer because there are legal questions. Just to be clear, I think you're talking about the Bolanos Blanco case that went to federal court, and this was a change of the language of procedures. You're correct in saying that the commissioner granted the change of language after periods of reluctance, yes, and refused the request from Bolanos' counsel to have all documents retranslated that were already presented when the initial language was English. And simply indicate the legal aspect, I think everyone here knows probably that neither the Charter, neither the Official Languages Act addresses documentary evidence. Now, that said, the IRB does have its own rules that require the minister to table documentary evidence in the language of the proceedings chosen by the subject. However, what isn't a requirement, and this is the federal court that agreed with us, what is not an obligation is that when there is a change in the language of proceedings and documents have already been translated, to retranslate the documents.
Excuse me for interrupting you, but since we're talking about Cabanos, this was done well before the procedure began. At the very beginning of the process, it was impossible to ask for a change of language procedure because the person was never asked at the beginning in which language he wished to have the proceedings conducted. And he was told later on that it was too late. If it is too late then, when is this application for a change to be made? I think that the federal court did make another finding. If you would look at this particular case, Bonanos, you will see that the court did find that Mr. Bonanos did in fact indicate his choice of language, and it was not a matter of the Canadian Border Agency making a choice of this. This is not what Mr. Bonanos has claimed. I won't go into the details of this. You were successful. But what I am asking, the question I'm raising is whether we should not choose to proceed in French in Montreal as the choice would be made in Toronto to proceed in English. And if the decision is made to conduct proceedings in English, and even before the beginning a lawyer asks for a translation of the evidence in French, it seems to me that it is quite legitimate to have this done. This is in keeping with the spirit of the language legislation. The fact that you were successful in the federal court is not a great surprise to me. The question of language is dealt with. You received certain documents. There are rules that apply to this in each of the three divisions, and they indicate that it is the subject of proceedings who does make the choice of language and to make an indication of this. This is part of the personal information form that is filled out, the form that we make use of. I realized that there was some confusion in the case of Mr. Blanco, and we did give a copy to the committee clerk, a copy of a memorandum that was distributed to all our employees, the 29th of June. We didn't choose this date deliberately. It does clearly indicate, it gives very clear instructions to everyone in the board about what the requirements are when it comes to a decision relating to the change of language before the hearings begin or even during the proceedings. In such a case, taking into account these new instructions, when is it considered that the evidence has been tabled? Is it the time when the documents are produced or when the proceedings begin? If it's when the agency prepares these documents, then the change in procedure is of no use, because people will write to them in English and say it's too bad, these documents are already available in English. You may ask for a change of language or procedure, but the documents will not be retranslated. It seems to me that this should take place as quickly as possible. And secondly, we do have a number of cases where the file is tabled in both languages. The language of proceedings has to be either English or French. It can't be both. There's the inverse procedure. The regulations are adopted to the reality because, in fact, the agency works basically in English. Let me explain one thing. I'd like to go back to the first point, and then I'd also like to deal with the second one. If, as you suggest, we were to begin all our procedures in French, this would be against the Charter, and this would be against the Official Languages Act. It is up to the subject of proceedings to choose a language of procedure, and this is done in keeping with our rules. They indicate their choice. Thank you. The time is up. We'll continue with Mr. Godin. Thank you. I'd like to welcome our witnesses. Perhaps we could continue on this explanation, because you say that by default it is not in English. No, not at all. Even if it takes place in English, it's not more likely to take place in English and in French. It is at the request of the subject of proceedings, 100%. We have to respect the rules respecting both the Canadian Charter as well as the Official Languages Act. If there's an application, if at the beginning the choice of language is known, then this is the basis for the proceedings. There's no difference in Toronto then? When it comes to the evidence, the department is required to table the evidence in the language of proceedings. In the example that was given a while ago, the choice of the person should normally have been indicated. The information form that was filled out by the person. And can you tell me what the procedure is? Let's say that the language of choice was indicated. The person may be in Montreal but decided to choose English, represented by counsel who speaks English well, but the lawyer is not too happy with the way things are working out. He has to change a lawyer. He then chooses a French-speaking lawyer. What would the procedure then be to change all the evidence, as Ms. Cox-Duquette explained, the documentation that was already tabled, that has already been made available? Let's assume proceedings began in English. There was evidence or documentation in English, and it remains in English even if the language of proceedings changes. But once the language of proceedings changes to French, at that point, any further documentation must be tabled in French. So that means that if we want the person to receive justice, the department will be tabling evidence and documents in English because English was the first choice. But as I gather from what you say, once the change is made, then at that point, the language changes. It is the language chosen by the subject of the proceedings. There may be situations where the subject of the proceedings has chosen English, but let us assume that in Montreal, and this would be the opposite in Vancouver, someone may choose English, but then has a lawyer who prefers to speak to the board or the tribunal in French. At that point, we must ensure that there's interpretation from French to English for the subject of proceedings. But if the subject of proceedings wishes to change with a new lawyer, giving this as an example, a francophone who doesn't speak English, but if the person wants to have the documents that were previously tabled to the new language of proceedings, what exactly do you do? You say that nothing is done. I think that there are 2 points that should be emphasized here. First of all, the subject proceedings may choose a language of proceedings on the basis of the fact that the lawyer is more comfortable in the other language. But even if the language of proceedings is English or French, whatever the case may be, we must not forget that any person who appears before a federal tribunal is entitled to speak to the court in the official language of their choice. There's always this possibility, no matter what language may have been chosen. I'm not talking about the language to be used before the tribunal, but the documents. Yes, for the documents, yes, you were correct. This is the way things work. So I was correct. I understood that if the initial choice was English, let's say, and later on there is a lawyer who prefers French, then at that point the documents can be tabled in French, but the previous document is in the other language. If the person says that I need to have these documents translated in the other language, because after all, it's not the subject of proceedings who is responsible for presenting the case. Does that mean that the documents are translated? The rule does impose certain requirements. There was no one preventing anyone from translating documents, but the obligation on the department is to conduct this in French unless there is a change that has been made in the language of procedure. You would say that we would have to change the legislation if we wanted to do otherwise? There is nothing preventing the person from having a translation done at his expense. But if the original document was drafted in the other language, would you say that the small number of complaints that you received, there's a very small number, a minimal number, that if I were an immigrant, I don't think I'd want to draw attention to myself by the lawyers who appear before us are not immigrants. If it is the client who makes the complaint, then the client will receive services from a lawyer. Normally, in view of the fact that lots of people who appear before us are newly arrived in Canada, normally they rely on the advice that they receive from their lawyers or from consultants. Do you receive many requests to change the proceedings once they have begun? This year, let's see, I think I have the figures here. I think there were 127 requests so far, requests to change the language of proceedings. I don't have the breakdown of how the two languages. Thank you, Mr. Godin. The Parliamentary Secretary. Thank you, Mr. Chair. I do have a copy of the IRB language plan as it was tabled this morning, and I'd like to concentrate specifically on something that was mentioned by Mr. Coakley, Part 3 of the Official Languages Act. First of all, when it comes to the first aim, I won't read it. The first goal, because we only have 7 minutes. Initiative number 1 is to develop clear procedures, directives, or guidelines on the interpretation and application of official languages in the administration of justice. Part 3 of the OLA, specifically on a number of key decisions. My question then on this goal. Can you tell me what the specific steps are for this procedure? Because we are almost in 2011. Can you tell me whether it is sufficient? Because in the update and comments you've identified you refer to briefing notes that have been sent to employees to ensure compliance in the application of official languages and so forth. I think that you've also received a memorandum that I mentioned previously that was signed to all the employees on the 24th of June 2009, explaining the goals, the language goals, in the context of the hearings. These are the briefing notes that are referred to here in page 1. What remains to be done are certain changes to our procedure manuals, taking into account the instructions that are to be found in these briefing notes. So we have to make changes to the procedures manual. But I think these notes are fairly thorough. And they were sent out because there was a certain confusion in the particular instance of Mr. Blanco. We wanted to indicate to all employees and decision makers what the specific requirements were in this matter. I could perhaps also add the Bill C-11, Measures for Refugees, perhaps about 2 or 3 months ago, we decided that we would include a number of aspects in our reform procedure. All our manuals will be reviewed, taking into account this reform, and we'll be making use of this opportunity to include clearer instructions when necessary. Goal 2, it talks about identifying informing and educating different groups of registry employees and raising the awareness of their obligations and responsibilities. Can you tell us how you intend to implement this and give us specific examples of action that has already been taken? I'll ask Mr. Gaston to give you more information about this. This is the first time that the IRB has developed an official languages plan, one that was approved by the Human Resources Committee. And more specifically, this particular initiative will be working in close cooperation with the Operations Directorate to ensure that the registry will be properly informed. There was the note sent out in June 2009 in order to make employees aware, the registry employees aware. And we intend to pay far much more attention to this and to make people aware of their rights when it comes to official languages. Do you have any assessment system? When it comes to the evaluation of how things are proceeding, first of all, we are working with Human Resources as well as with the Operations Directorate. We intend to target the places where greater attention must be paid to language requirements, the need for more awareness among registry employees. We will be focusing our efforts then in order to get the best bang for the buck. And we've been working very closely with operations here. This is the first time that initiative such as this has been taken. It's done on a quarterly basis to determine how these objectives are being implemented. We've given ourselves a 2-year period. And we expect that the effect will be felt. And we expect to assess the results.
Gaston, I think in a broader context, this committee has been looking at best practices across departments. We've got departments with different grades, if you will. Interestingly, in some areas of their departments, they've done very well. In others, they haven't. There's been a grade to establish an overall performance. I would encourage you to take a look at some of those. I think eventually we would want to understand, and we're trying to pull out best practices across different departments to see how they apply. I have less than 30 seconds here, I noticed, to deal with Objective 3, but I just, maybe I'll get right to the point here. Your priorities...
I would suggest, Mr.
You would suggest that I don't do that? Okay.
That you keep it for the next round, because we don't have the same timing, I guess.
Asking the tough questions.
Excuse me, Mr. Chair, could I just checked something and I provided some incorrect information to Mr. Godin a minute ago. If I could just correct that for the record.
Go ahead.
Of the cases that have been filed so far in 2010, we've had 164 requests, not 125. That was 2009 data I gave you. I'm sorry.
Okay. Monsieur Bélanger, deuxième tour.
Mr. Bélanger, second round. Thank you, Mr. Chair. I simply want to continue with the Government Council appointment issue. Mr. Coakley, generally speaking, do appointments follow the guidance as to satisfy linguistic needs? For a period of time, there was a shortage of appointments made by the Governing Council, and since those appointments were made, yes, appointments have satisfied linguistic requirements. So there was a time when there was a gap. Well, perhaps during 18 months at the Protection Division, out of 127 decisions, we had a little over 50 vacancies. Those vacancies were filled, and according to our needs. As I indicated earlier, it's an issue of linguistic capacity, gender balance, and other issues as well. With regard to your budget, Having to provide translation or interpretation services, does that lead to budget constraints? Well, Mr. Gascon is also our Chief Financial Officer. There are always budget constraints, but currently, do we have enough money to do the work we need to? I'd say yes, but Serge, would you add anything? Well, currently, at the IRB, since I'm in place, there have not been additional pressures with regard to translation services required. We've always ensured that the budget envelope for translation services was appropriate to meet the demand. So it can be said, therefore, that there were no cases where demand for translation and interpretation was not met because of financial constraints. Absolutely. Now, for Part 7, in your plan, your official languages plan, 2009-2011, I don't see Part 7 anywhere. Can you explain to me why? I can perhaps start, and then Mr. Gascon can continue. As you probably know, Part 7 is a challenge for many departments. It's particularly a challenge for an administrative tribunal because of its nature and our involvement with the people appearing and the communities that represent subjects. We have certain restrictions to protect the impartiality of the tribunal. So that's one element. Another one is that since we are a small organization compared to other federal departments, for instance, Canadian Heritage does not include us in the group of departments that have to report and have a specific plan in place. The challenge for us, for example, we don't provide groups with subsidies. We have regular meetings with people who we call an advisory committee on practices and procedures, where we meet with stakeholders, but they are institutions, whether the Bar Association or the Refugee Law Association in Ontario or the Canadian Council for Refugees. So these are mainly lawyers from legal associations. So I'd like to interrupt you, Mr. Coakley. I only have a minute left. I understand that Part 7 is a challenge, but if there's nothing in your plan on Part 7, that says that no efforts are being made. I can say that this was discussed. I know that's insufficient. Well, listen. Go ahead, Mr. Gascon, but I'd like to keep it 30 seconds. I note that official languages are not part of your strategic plan. I also note, Mr. Coakley, that official languages are not part of your personal objectives. There has been no assessment by the Official Languages Commissioner since I don't know when, and there is absolutely nothing regarding Part 7, which is a legal obligation you have in terms of official languages. So I find that this leaves something to be desired. Thank you, Mr. Bélanger. We'll follow up with Mr. Saint-Cyr. Thank you. I'd like to continue along the preceding questions I asked. You said that it's up to subjects to decide the language, but that does not set with reality. Last year, Rue Frontenac, the newspaper, came out with stats on that at the Immigration Appeal Division in Montreal, the second largest francophone city in the world. Most decisions were rendered in English. So it isn't true that that's how things are done. It's not because people asked for hearings to be held in English. The fact is, and perhaps you'll have to get this message across to the CBSA officials, but the fact is that officials at CBSA, when they receive an application from someone or an application for an interview and that person doesn't speak French, they automatically check English without saying that they're in Quebec and that you could have a legal counsel in French or a consultant in French, and they're not notified of that. The English box is simply checked off. And when they come before you, documents are tabled in English, and even if the client or subject and counsel, even before the start of the proceedings, ask for documents to translate it, well, they're told, well, the document's already produced in English. So that's a trap. And the stats bear that out. What it shows that in Montreal, at the Immigration Appeal Division and the Immigration Division, last year, most of decisions were rendered in English. Do you not think that there are shortcomings in the system to lead to such results? You're perhaps correct in saying that at the Immigration Division, at the Immigration Appeal Division, since 2006 until 2010, in those two sections, yes, most cases, 51 to 49%, but most cases were rendered in English. At the Refugee Division, since 2006, approximately 2/3 of cases or more were heard in French. It must be said that proceedings in each sections are different. For instance, if you take, for example, the Refugee Protection Division, that is where the CBSA will meet with individuals who appear at the border. It is quite possible that the CBSA will check off an English box and start drafting documents in English, port of entry notes in English. But the documents that start the proceedings is the personal information form that the subject has to fill out him or herself, and is on that form where we ask the subject to indicate what language they want to choose. And the notes that were taken by the CBSA have no impact on the choice of language. So on the personal information form, actually that is the document, the PIF, which indicates the language of the proceedings. I apologize. I'll take this opportunity because you answered my question. I understand that we disagree basically on what is going on the ground, but I have a more specific question. Recently we had a case of the agency which tabled a document in English when the proceedings were being held in French. When the council, 5-6 minutes later, objected to the tabling of that document, the commissioner said that he should have made that objection immediately, not 5 or 6 minutes later. Is that normal practice, or is that an exception? I don't know if you're, again, talking about notes taken by the CBSA. No, I'm not talking about that. I'm talking about, the language of proceedings was in French, and the defense tabled a French document, and then the counsel said, well, the lawyer said that the document wasn't in the language of the proceedings. Well, the commissioner said you should have made an objection 5 minutes ago, and now it's too late. That's not the official policy of the IRB, is it? So there's no delay in place. It's not because the council will realize 5 or 6 minutes later that the document was in English that they can't object. Well, objections have to be made as quickly as possible. But if you're saying the objection was made 5 or 6 minutes later, it seems to me that it should have been agreed to. Perhaps 5 months later, I can understand. But thank you, Mr. St-Cyr. Already over, gee. If you have information to transmit or statistics, you could send them to our clerk, perhaps not this morning, but later on, and we'd appreciate to make them available to committee members. We will move on with Mr. Lauzon. Thank you, Mr. Chair. And I'd like to welcome all of our witnesses this morning.
And talk about the IRB's human resources, the hiring situation. Recently, the IRB lost a legal bid to shut down some investigations into about a dozen appointments to its permanent staff. Are you? I'm sure that you're aware of.
I am aware of the situation. Yes.
And according to the Public Service Commission, the candidate was offered a conditional appointment with a requirement that they had to meet the official language requirement. I assume later down, this is probably a bilingual non-imperative position maybe, or a bilingual imperative position, but the person had to meet the language standards. Then, when the candidate failed to meet this level after their second language test, the individual was appointed, and in this case, merit obviously was not met. So, how do you explain that?
I'm not aware of the specific. I mean, as you may be aware, the Public Service Commission conducted an audit into the IRB, and they had a number of files where they had some concerns. In terms of ones where there were language concerns, I'm aware of the specifics of one instance and it happened here in the National Capital Region, where we hired an individual from another federal organization, but not an organization that's part of the core public service. The individual was rated bilingual at that institution. Excuse me. Was offered a job at the IRB on the basis that he or she, and I'm not sure whether it was a man or a woman, quite frankly, that they met the language requirements. Then it became apparent that the language test that they had passed at the other institution was not valid for public service purposes, that the only valid test is a Public Service Commission administered test. The individual failed the Public Service Commission test, but by that point had quit his or her job at the other federal institution. The manager did downgrade the language requirements in order to allow the individual to take the job with the board. That should not have happened. I can say it hadn't happened before any of the four of us were at the Immigration Refugee Board, but it should not have happened. But I think what motivated the manager in those circumstances was the sort of the personal situation of the individual who had quit a job in good faith and then was caught by a requirement that we should have been aware of at the time, but had been now that individual is no longer with us. And the position has been filled with somebody who does meet the original language requirements.
Okay, what's been put in place so that doesn't happen again?
I'll let our DG of HR talk about that.
The PSC audit raised a number of points where we took the leadership in establishing policies, procedures, tools for our HR advisors and our managers so that for every staffing action, this does not occur again. We also do a quality assurance before the appointment is made to ensure that everything is compliant.
But wouldn't it just be common sense that you would, if a person was going to a bilingual position, that you'd test them in both official languages?
A second language evaluation in the public service is good for 5 years, I believe.
Well, if it's exempt.
Unless exempt, yeah. So this was the problem in this particular case. The individual had a language exam results, but they were not a Public Service Commission language results. They were the other federal employer. And there was confusion. There shouldn't have been, because the HR community should know this, but there was confusion around whether or not those results were valid. But yes, I mean, within the public service, it's quite clear. If you have a valid language result, then you can be appointed. If you do not, then you need to have a valid language test before you can be appointed.
So could you assure me, someone on the panel here, assure me that never in future that there will be someone who doesn't meet the language qualification appointed to any position in the IRB? Can you make that commitment?
I can commit to you that we have procedures in place which includes at the moment 100% verification of by an independent within the HR group, an independent individual who has not been involved in the staffing profile to that point. 100%. We currently have 100% checking of every single staffing action that we're doing. But we're all human, so I don't think I would ever use the word never in that context.
You can't blame me for trying.
No.
In one external non-advertised process, one of the essential qualifications was for the position to be bilingual. However, after language testing, so now you actually did the testing there, the employee failed to meet the essential requirement of the position, and the manager downgraded the position. Like, are you making the position? Explain. Can somebody explain?
again, I'm aware of this, but the particular case I'm aware of, the position, the language profile of the position was downgraded to enable the individual, to give the individual a job because he or she, and again, I'm not sure whether it was a man or a woman, had quit their previous job on the basis that we had made them a job offer. No, that should not happen. Having said that, I think every public service manager who's run competitions over the course of their career has faced a situation where you've posted a position with a particular linguistic profile, and it's proven to be unsuccessful. That nobody who meets the linguistic profile also meets all of the other merit criteria. And as managers, we face that all the time. And sometimes what you have to do as a manager is revise or step back and have a look at the language profile, and sometimes you adjust it, ensuring that you can provide the level of language service in some other way. In a circumstance like that, though, what you are also obliged to do is to repost the position and rerun the competition from scratch, not just take the one person.
Thank you.
Downgraded.
Thank you, Mr. Lauzon. Thank you. Alors, on va conclure avec Monsieur Godin.
Conclude with Mr. Godin. Thank you, Mr. Chair. How many commissioners can hear proceedings in French? Well, at the Refugee Protection Division, there are 40 bilingual staff plus 7 francophones, therefore 47 in French, who are able to hear cases in French. At the Appeal Division, there are 8 bilingual people. How many? 8. 8 at the Appeal Division. And at the Immigration Division, there are 11 people who are currently bilingual. I don't have the breakdown francophone, anglophone, bilingual, but bilingual people are able to hear cases. Where's the regional center? In Toronto. So at the Toronto, there are 6 bilingual positions and 69 anglophones. At the Protection Division, yes. And at the other division, that's the Montreal office. The Immigration Appeal Division. So at the Immigration Appeal Division, there are 18 anglophones and there are no bilingual staff. How can people receive French language services if there are no bilingual people there? Well, as I indicated in my opening remarks, in such circumstances, either it will ask someone, a francophone or a bilingual person, to come from Vancouver or Montreal to Toronto, or will offer a video conferencing services. Now, do you not ask for commissioners to be bilingual? These commissioners are appointed by the Governor Council, but in Ontario, out of 11 million people, couldn't you find bilingual commissioners in Toronto? Yes, but they're not all located in Toronto, unfortunately. Well, I'm not in Toronto. I'm in New Brunswick and at Ottawa today. Well, I know, but our commissioners have to remain in Toronto. Well, the question I have is, when there are vacancies for bilingual positions, people can travel. I'm sure people who live in Ottawa or in the Vanier region apply and move to Toronto if there's a commissioner position vacant. So are there bilingual job offers in Toronto? Well, currently at the Immigration Appeal Division, well, in 2006, there were 10 people who asked for hearings in French in 2007, 2013, 2008, 7, 2009, 17 hearings, and up to date 15 this year. So that's at the Appeal Division. So 3 bilingual staff in Toronto and 15 anglophones at the Immigration Division. These are officials at the Immigration Division. So we have bilingual officials who are part of the public service.
People in the Appeal Division and the other division are people who are appointed from the street, so to speak, whereas the others are officials in the public service. I was told that there were only 10 appeals, but when you apply for a position, is it a bilingual position? In the case of the immigration section, yes, because they are officials. When it comes to the appeal division and the protection division, these are appointments of order and council, so it cannot be specified that these positions are bilingual. It's the Governor and Council who appoints these people. The Governor and Council who makes a decision. In other words, they don't take into consideration the need to have bilingual persons in Toronto. This is taken into account, but they do not appoint them. I want to find out whether there are any. Therefore, they don't take this into account. As I say, there's very little demand. It's because there's very little demand. There's not much demand in Toronto because these people, we can have people who travel to Toronto from Montreal to hold hearings. You say that there were 10 appeals? Yes. There were 15 appeals applied for in French in Toronto. Do these people have to wait longer than others? We are able to. Previously, we're not able to. Thank you, Mr. Godin. Mr. Chair, if I may raise a point. I thought you had a special announcement to make.
Given the nature of today, I thought that I'd wish Mr. Coakley a happy birthday.
So, on behalf of, alors, Monsieur le Vice-président, les membres du comité se joignent à vous pour
the committee members would like to join with you in expressing your wishes. We'd like to thank you. This is our first meeting. We may have an opportunity to meet again, but you will be able to continue your efforts on behalf of language equality. We are going to have our in-camera session now.